Welcome to Out of Court and Out of Conflict, presented by Wasinger Law Office.
Welcome to Out of Court and Out of Conflict, your guide to estate law and probate solutions by Wasinger Law Office. Join us today as we unravel legal complexities and secure your family's legacy with experienced attorney Matt Wasinger. I am your host, Kevin Rosenquist, and today's episode is Power of Attorney and Healthcare Directives. What are they, and why do you need them? Matt, great to see you again.
Great to see you, Kevin. Thanks for having me back.
Yeah, absolutely. So let's open the show by having you explain exactly what a power of attorney is and how it works specifically in Florida.
Powers of attorney are giving someone else the authority to make financial decisions, in most cases, financial decisions or related to finances and assets over whatever you have going on. So, for instance, if I name you my power of attorney and I need you to sign a mortgage for me, technically under Florida law, you'd be able to go sign that mortgage as power of attorney for me. Let's say I was out of the country and I needed my power of attorney to do it to get something done. That's, a rare instance, but that's a way that a power of attorney works. So you're giving someone else the authority to make decisions on your behalf as it relates to a whole host of matters, and what those matters are dependent on what you actually put in the power of attorney itself.
Okay, what is the difference between a general power of attorney and a durable power of attorney? Those are some terms I've heard before.
So a general power of attorney is when you have a power of attorney that is in place, but if you become incapacitated for some reason, it cuts off. It doesn't work. A durable power of attorney is one that works even through incompetency. So it's still effective, and your power of attorney can do things on your behalf even if you are declared incompetent or incapacitated for any reason. But both of them would still cut off once you die. They're gone. So you have to be alive and unwilling or unable to execute whatever you need to execute over your assets for the power of attorney to work. And in Florida specifically, there's nothing that is a springing power of attorney, meaning there's no event. You can't set it up to say, if this happens, then this kicks into gear. Florida removed that option. Some states allow that. When you execute a power of attorney in Florida, whatever the powers are in that power of attorney, they're effective immediately, and that person can go use that power of attorney whenever they need to on your behalf, which also makes it a little more important on who you choose to be your power of attorney, because if they decide to go rogue and use it for whatever their nefarious purposes may be, they could do that technically.
So why did they change that law? Do you know?
I do not, other than I'm sure more than anything, it just relieves some of the liability on the people relying on a power of attorney, instead of having to go through and check, okay, and take some of the interpretation out, right? Okay, if this happens, and it could be something very specific, then there's a different interpretation of whether that event has happened or not, or what constitutes that event happening. So that would be my guess. I have not looked into specifically why they changed it, though.
That does make sense, though. That there could be too much gray area there where things can get a little weird. So what happens if someone becomes incapacitated and doesn't have a power of attorney or any sort of healthcare directive in place? For
the financial power of attorney, they become incapacitated, you have to go to court and try to get yourself or whomever you're trying to appoint as a power of attorney over them. Same thing with a medical power of attorney, which is for your medical decisions. If you don't have that in place ahead of time, you're going to court to be provided some sort of power, typically a guardianship almost situation, to be able to make decisions financially or medically for those people. And it's obviously a much more involved process. It takes longer and it's more expensive because it's court. You have to get a judge to decide, and people get to chime in. So that's where a lot of conflict can show up, is when you're dealing with a power of attorney, when you're dealing with a guardianship situation in court, because everybody's got to be put on notice, and the judge has to listen to everybody to determine what the best course of action is.
How does a power of attorney fit into an overall state plan? Why is it a critical document to include as part of that?
Well, because it covers the events of when you're unable to take care of yourself, right? Mm-hmm. So, a will doesn't kick in until you die. So a will is limited from that perspective. So without a power of attorney attached to it, your estate plan is going to be filled with holes that'll require someone to go to court. And as you know, our whole premise is out of court, out of conflict. And the easiest way to do that is to make sure that you have a whole package of documents done whenever you do a estate plan. That's why my office will very rarely do one-off powers of attorney or a will or something. We try to do it all in packages because we want what you're trying to accomplish to actually work when you need it versus there being a hole left somewhere in there.
Yeah, that makes sense. More of a comprehensive plan in place. Yeah. When might someone need to activate that power of attorney, and who decides when it gets activated?
Well, that goes to Florida. It's activated immediately. Right. So once you sign it, your power of attorney can go, sign documents, depends on what you list, right? So a limited power of attorney will list very specific powers, right? Like then maybe someone will execute a limited power of attorney just for the purposes of signing some documents because they're going to be out of the country, or they know they're going to be in surgery for something or another. They need to make sure this is done. But otherwise, whatever powers are listed in there, your power of attorney can start moving right away. And sometimes it is as simple as, we're going to be out of the country. My power of attorney can sign this on my behalf while we're gone. If it's, today with Zoom and all the different things, that's less of a dire need these days, but it's still, a helpful tool. And then, biggest sense of the term, if they're incapacitated, they can't make those decisions, or they need someone to be helping them with their financial situation or assets or anything while they're incapacitated, is when that really comes into play for a durable or financial power of attorney. As far as a medical power of attorney, that almost always is going to be when you're incapacitated, because they're worded in such a way. It's like, if I'm unable or unwilling to make decisions for myself, this person is able to make medical decisions for me.
Okay, and in what situations would someone want a durable one? The medical one makes a lot of sense.
I think in any situation, you want the ability to have, whether it's your spouse or a trusted friend, advisor, whatever, be able to make decisions when you can't on your behalf, because it could be as simple as your significant other needs to pay the bills, but she doesn't have access to your account, or he or she doesn't have access to your account. Your power of attorney then is able to get access to those accounts. It's one of the reasons why we recommend parents, whenever their kids turn 18, to have them execute a financial durable power of attorney and medical power of attorneys, because even though they might still be basically living off of their parents, or their parents making all the decisions for them as if they were still minors, technically they're not going to be able to do any of that. So for instance, if they're on vacation somewhere and they lose their ID and they lose, their debit cards and access cards, parents can't just call up the bank and handle all that stuff for them without documentation that they're allowed to, because they're adults at that point. So that's one of the reasons why having durable power of attorney is extremely important.
What about healthcare directives? I mentioned those before. How do they differ from a power of attorney specifically for healthcare decisions?
Well, the medical power of attorney itself is the one where you've got someone making medical decisions for you. Then there's different healthcare directives you can use. The big one that we always recommend is a living will, which a living will in Florida is kind of the do not resuscitate document. So it's saying, in these specific instances, if I'm in these instances and my medical power of attorney and a physician, or you can name a disability panel, decide that I am in one of these positions and I'm not going to make it back out of it, that's the time to stop medical intervention and let me go. And the Terri Schiavo case in Florida was the real famous one. That she didn't have a living will that specified whether she should get nutrition or hydration. Husband said she didn't want to live like that. Parents said she did, or were unwilling to let that go.
Right.
So it took 15 years. It went all the way to the Supreme Court, where she was, for all intents and purposes, in a persistent vegetative state, but was kept alive with a feeding tube, nutrition and hydration. So that living will is really important when you're trying to put together a comprehensive estate plan, because you can also make different terms, right? It doesn't have to be, let's say you get into a coma and they say, we don't think Kevin's coming out of this. Well, if you put in that living will, if I'm in a coma for any reason, 30 days to pop back out of it. If not, then it's time to pull the plug. So you can kind of limit some of that stuff if people are worried about it. But mostly we point out that you don't want you don't want your family to be in a position where they have to make the decision to whether or not to keep you alive and for how long, while you're financially just running up massive hospital bills, because we know it's not cheap. And it takes kind of the burden off of them in a terrible situation where they let you go based on your wishes versus them having to make the ultimate decision for you.
Yeah, wow. I remember that Terri Schiavo case. I did not realize it took 15 years.
Yeah, it went on forever. And that's part of it, part of the appeals process, and part of starting in a trial court, going back and forth through that. Judge makes a decision, they appeal it. Those appeals can take years, and then they kept going up and appealed to the Supreme Court. I mean, it was all over the place. So, and it's not something anyone should be wanting their family to go through if they can help it. And that's why voluntarily making these decisions ahead of time and putting it together in a package, for an estate plan is extremely important if the goal is to keep your family out of court and conflict after you're gone.
And just the emotional toll that takes over 15 years. I mean, for everybody involved, that's a great example of why everybody should be doing this, should be talking to someone like you, for sure.
Yeah.
Can someone have both a power of attorney for financial decisions and a separate healthcare directive, or is it common for these to be combined?
If someone's combining them, I would recommend they stop. It's better to have very separate, distinct versions, because they're used in very separate, distinct situations, and you don't necessarily want those to overlap. The other reason you want them separate is you might not want the same people making those decisions, right? You might want your spouse being your medical power of attorney, but a close friend or financial advisor being your financial power of attorney, or vice versa in some way, shape, or form, to where these people are the best at making those decisions, because they're doing very different functions. And sometimes that person isn't the best person to handle your finances if you're unable to, isn't the best person to make your medical decisions. Right. And you want to make sure that gives you the ability to put different people in different orders to handle those jobs, essentially.
Are there any limitations to the authority granted by a power of attorney or a healthcare directive?
Yeah, the limitations are what you put in there, essentially. Okay. So our durable power of attorneys are very long, and we have a lot of specific powers that we have our clients initial to say they're authorizing that. And the reason is when you're dealing with financial institutions, sometimes they'll say, oh, this doesn't specifically say that your power of attorney is allowed to do this, so we're not going to accept it. And then you're going back to court anyway. So we create a long list of things that you're providing powers to, specifically for that, to avoid those situations. The alternative, though, is if you only want it for specific things, you just limit those powers in that power of attorney. You limit what the options are for that power of attorney to exercise. If you're worried about limiting your liability to somebody else, or not trustworthy with, let's say real estate, but they're great with, budgeting, stuff, whatever it is, you can change that up or limit it and specifically list the powers that you want them to have or not.
Okay. Are there any situations where they can make a decision outside of the scope of what's outlined in the documents?
No, they shouldn't be. If whoever's relying on them is doing their job, which is whatever's in there is what they're allowed to do or not allowed to do, and they should be following that. That's the whole purpose of a legal document, right? Mm-hmm. It's telling you exactly what's allowed and what's not. And if anyone's not following that, then they're going to be in trouble at some point down the line.
Why is it so critical that people sit down with a firm like yours to go over these options and properly set up these critical documents that they may someday need, instead of just trying out one of the online places to get all your stuff together?
Well, the number one thing is the online versions, the DIY versions aren't going to follow all the necessary steps to make sure that you've got backstops to what you're choosing, right? Or they're going to be much more limited than what we're providing. And also, if you're looking for specific legal language to allow specific powers or disallow or anything, having an attorney drafting those specific changes is much better than you just typing it out yourself. And so what we do and what we think is important and why we change the way we do estate planning versus most other firms is we want it all comprehensive. What happens if this person isn't there? Who's next? And if they're not there, who's next? We try to put as many backstops in as we can to cover all the bases to make sure that there's no holes in the estate plan and it works when you need it to. And those DIY or online versions aren't always asking all of those questions as much as they're just spitting out a document for you that you can execute, and it might work for specifically what you're trying to do, but it's not necessarily going to work in all the instances that you need it, or even think about the reason, or even give you the reason to think about other areas where you need it.
So I can't just have ChatGPT write it up for me, Matt?
Well, I'm sure there's people doing that, but I'm not sure it's a good idea. As your attorney, I would not recommend it.
All righty. Well, thanks for tuning in to Out of Court and Out of Conflict with experienced attorney Matt Wasinger. For more information or to connect with Matt, visit wasingerlawoffice.com. And please be sure to like, subscribe, and leave us a review in the comments. Matt, always great to see you. Thanks for being here.
Thank you, Kevin.
Thanks for watching. If you like this video, don't forget to hit that like button and subscribe to our channel for more amazing videos like this one.